Litigation is a process. It's a procedure, and there are stages and there are phases of litigation. A temporary hearing is where the judge has an opportunity to stop the bleeding in the divorce temporarily. Just add a Band-Aid to a situation that needs an immediate yet temporary relief until such time there is a final hearing or the parties reach an agreement. A temporary hearing is very limited in what evidence can be presented because, again, it is just a temporary resolution until such time there is a final order that is entered in the case. Temporary hearings can be very effective in leading up into the final hearing. For instance, evidence that is heard in a temporary hearing can be used at a final hearing with notice to the parties. I had a client who had some very sensitive issues occurring with his minor daughter, who was 7 years old, and we had to file for a temporary hearing so that the judge could hear some of the immediate issues. In that case, all of the evidence that we submitted and tendered as part of the temporary hearing, we now can use in the final hearing because we made a request to the court to reserve that information and to rely on that information in subsequent hearings. Temporary hearings are very effective, and in that case, it was extremely effective because while that information and while that evidence was ripe, we were able to ascertain that evidence, and now we have that evidence for the final hearing. And of course, my male client was awarded custody temporarily of his minor 7-year-old daughter, and he will have temporary custody until we have a final hearing, and the court will have a final hearing and hear the final evidence and make a ruling at that time. At Fenwick Thompson and Associates, we inform and we empower. You're not just another client. You're like family. Schedule a confidential consultation today.